Court does call the cases of the people versus Jason Allen.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Patewithan on behalf of Mr. Allen, who appears via Zoom from the Wayne County Jail. Sir, can you please state your name for the court?
Jason Allen.
All right.
We are jumping straight into a packed docket, and right away you can feel the weight of what's happening here. 13 cases called at once for Jason Allen, and before anyone gets comfortable, that number jumps to 15. That alone tells you this is not a one-off mistake. This is a pattern, and patterns matter in court. Judge Simpson, calm but methodical, is already setting the tone. Procedure first, clarity second, consequences always. Notice how defense counsel immediately pivots to a global resolution. That's legal shorthand for, let's wrap everything up in one coordinated deal instead of fighting 15 separate battles. That strategy can save time, money, and potentially limit exposure. But it also means the defendant is likely conceding something significant. When you hear 2 to 3 week adjournment, that's not just scheduling, that's negotiation happening behind the scenes. And here's something critical. The court carefully addresses conflicts, waivers, and jurisdiction before touching the substance. That may sound technical, but it protects the entire case from being overturned later. Procedure is power in a courtroom. With retail fraud on the table and multiple misdemeanors being dismissed in exchange for a no-contest plea, the stakes are shifting quickly. The question is this strategic damage control, or just the beginning of a much larger reckoning?
I called all 13 cases.
Thank you, Your Honor. As to the 9 state matters, I was made aware this morning that there are 2, I believe, warrant requests pending that Ms. Londi made me aware of. We do believe—
Oh, to bring it to an even 15.
Pardon me, Your Honor?
Never mind.
Oh, sorry. So we believe a short adjournment would be able to accomplish those both being sworn out. And Ms. Londi and I have been in discussions about a global resolution of all these cases, which I have discussed with Mr. Allen. So I believe a 2 to 3 week adjournment would be able to accomplish all of that as far as all of the state cases. And then there is a resolution as to the Pittsfield Township matters, Your Honor.
Already?
Yes.
And as to the state cases, that's correct, Your Honor. I neglected to do the waiver. Would the court like me to do that now?
Sure.
Thank you, Your Honor. At this time, people would be come to the honor, the honorable court in the office of the defendant, not believe that any conflict exists, make waiver be avoided spelled out.
Likewise, Your Honor, or Natalie Pate on behalf of the Public Defender's Office, Your Honor. Likewise, our office does not believe a conflict exists between our office and this honorable court, but if one were to arise, we would therefore waive such a conflict.
Court also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. All right, now that we've gotten that out of the way. So on Pittsfield cases, there's a resolution.
Yes. Yes, Your Honor. Mr. Siller has extended an offer for the 4 Pittsfield Township misdemeanors to which Mr. Allen would plead no contest to the case ending in 0618. And
0618.
yes, Your Honor. He would plead no contest in that matter in the 3 other cases ending in 0437, ending in 1230, and ending in 1412 would be dismissed.
That is correct, Your Honor. So if you accept that no contest plea, I move it's 1230, 1412, and 0437.
All right, great. And Mr. Allen, is that what you wish to do?
Yes, Your Honor.
All right, fantastic. You can please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record.
Jason David Allen.
All right. Mr. Allen, it's this court's understanding you're going to plead no contest to the charge of retail fraud under the Pittsfield Township Ordinance. That is a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
Here's where things get serious. A no-contest plea may sound softer than guilty, but legally, for sentencing purposes, it's treated almost exactly the same. Judge Simpson makes that crystal clear. The only real difference: a no-contest plea can sometimes limit exposure in a related civil lawsuit. That's likely why defense counsel referenced potential civil liability. Now watch the judge methodically go through rights. Right to trial, right to confront witnesses, right to remain silent, right to be presumed innocent. This isn't just formality. Every single one of those rights is constitutional, and once waived, they're gone. What stands out here is how direct the judge is. No theatrics, no intimidation, just precise confirmation. You understand that? Repeated over and over. That repetition protects the record. If this case ever gets appealed, the transcript will show the defendant knowingly and voluntarily waived his rights. Retail fraud may be a misdemeanor, but 90 days in jail and financial penalties are real consequences. And with 15 cases swirling around him, this plea may only be one piece of a much bigger puzzle.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis or no contest plea.
Potential civil liability, Your Honor.
All right. And sir, to that charge, how do you plead?
No contest, Your Honor.
Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're also giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Not at this time.
Has anybody promised you anything other than what's been stated here today on the record regarding these 4 cases to get you to plead no contest?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 235678. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
But will accept the defendant's plea. Today is what? Court will accept the defendant's plea of no contest to that charge. Cases ending in 0437, 1230, and 1412. Those matters are dismissed as part of this plea agreement. I'll tell you what I'm going to do. Let's give me a sentencing date up. 6 weeks or more. About 2 months out.
There's March, I was gonna say March 26th at 1 p.m. or April 9th at 9 a.m.
Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 9th, 2025, 9 a.m.
The sentencing date being pushed 2 months out is not random. Judge Simpson even says it outright. If there's resolution on the other matters, he wants to combine sentencing. That's strategic judicial efficiency. Instead of stacking separate hearings, he's potentially consolidating consequences. From a defense standpoint, that can be helpful. If everything is resolved together, the judge sees the full picture, not just isolated incidents. But here's the flip side. If those other cases don't resolve cleanly, that April 9th date could turn into a very uncomfortable day. Also note the referral to probation for a presentence investigation. That means the court wants background, employment history, prior record, personal circumstances. Probation reports often shape sentencing more than people realize. Judges rely heavily on those recommendations. So this chapter closes with a plea entered, 3 cases dismissed, and sentencing looming. But the state matters still unresolved. And when multiple cases sit on the table like that, pressure builds fast.
Part of the reason I'm putting it out there, if there's a resolution on the other matters, we'll try to just combine sentencing.
Understood, Your Honor. Sounds
All
good.
right?
Thank you, Your Honor.
Thank
Yeah,
you.
what's the adjourned date for the state cases?
I didn't get one. You needed 2 or 3 weeks out. What do we have?
Yes, Your Honor.
March 5th or March 8th.
Thank you. Adjourn those matters to March 19th.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr. Allen. I'll talk to you again before the 19th.
Okay, thank you.
Thank
Thank you, Your
you.
Honor.
Court does call the case, People versus Gabrielle Boyd.
Special Lottie, people.
Good morning, Your Honor. Ida Sparhich on behalf of Ms. Gabrielle Boyd, who's present and standing to my right, Judge.
All right. This is an arraignment and pretrial.
That is correct, Judge. For purposes of arraignment, we waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
Thank you, Judge.
And what would we like to do with this case today?
Judge, I was just recently saying I filed my appearance yesterday as well as a discovery request. I will respectfully request an adjournment.
I will adjourn the pretrial in this matter to,
Thank you, Judge. And I just did have a really
hold
quick
on, let
question.
me give you a day.
Okay, sorry. That was going to be my question. Are all the pretrials have to be on a Wednesday? The only reason why I'm asking is my client is a full-time student and the Wednesday, it's a very tough day for her. If at all possible. If not, we'll take the 19th. College of Creative Studies in Detroit. She's a junior, Judge. If not, I would just then, I can fill out a.
We're gonna have to, they're all on Wednesdays.
Okay, I understand, Judge. Then I would, if at all possible, ask for the 19th. I think that will give me enough.
That way she can arrange things if necessary.
Thank you.
During the matter to March 19th, 2025, 9 a.m. or as your invite indicates. Esteban in this case, alleged to be issue.
.114, Your Honor. There was no crash. The defendant has no priors. People would request a Soberlink.
Judge, if I may say a couple of things.
Yes, go ahead.
Thank you. My client is 22 years old. As the prosecutor stated, there is no prior record whatsoever. She grew up in the city of Ann Arbor. She's gainfully employed. She's also a full-time student at College of Creative Studies. Her parents are both aware of this. I spoke to her father, in fact, before I even spoke to my client. And Dr. Boyd, her father, was not able to make it in today due to the fact that he's working and seeing patients. However, I believe he is on YouTube observing the proceedings, Judge.
Oh, he's watching, okay.
Okay, I would just respectfully, obviously, ask for a personal bond. My client does understand that usually with DUI cases, there is going to be some testing. If you're going to be in post-testing, Judge, she's respectfully asking for a Soberlink. It's a little bit easier to blow into with her schedule with school and work.
It's a 1-1. How old are you?
114.
114, Judge. My client is 22 years old.
Now we pivot to Gabrielle Boyd, and the tone shifts immediately. This is an arraignment and pretrial in what appears to be a DUI-related matter. The prosecution requests testing. Defense pushes for Soberlink instead of something more restrictive like a tether. Let's break this down. Soberlink is a portable breath device. You blow into it on schedule. A SCRAM tether, by contrast, is an ankle monitor that continuously detects alcohol. Huge difference in intrusiveness. Defense is smart here. They're advocating for flexibility because she's a full-time student. And then comes that $155,000 personal recognizance bond. That number may sound astronomical, but because it's PR, she doesn't have to post cash. It's a promise to appear. The amount signals seriousness, not immediate payment. Judge Simpson declines immediate Soberlink and leaves open random testing. That's judicial discretion in action. He's balancing risk, public safety, and a defendant with no prior record. She's 22, a student, no criminal history. The court is giving her room to prove this was an isolated mistake. But here's the engagement question. Do you think the court should have required testing immediately? Or was this a fair middle ground?
You grew up in Ann Arbor?
I did, sir.
What high school?
Pioneer High School.
Okay. It's okay.
Okay.
She could have said here on her skyline.
Then you would have
Then I would have
imposed
had,
SCRAM
I would have had to do something.
I understand, Judge. I get it. I didn't grow up here, but I get it.
I don't take that personal. You know, I just do. All right. All right. Set the defendant's bond at a $15,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons. You understand that?
Yes. Yes, Your Honor.
There should be no possession of any alcohol, recreational marijuana, or any illegal drugs. I am not going to, at this time, put her on a Soberlink. I'm going to leave it
Thank you, Judge.
in terms of that. However, you could be called in for random testing at any point. You understand?
I understand, Your Honor.
All right.
Thank you, Judge. My client does have a medical marijuana card. I know you stated no recreational use. She's not using recreational marijuana, but as far as providing the proof, is that something that I could just provide to the front counter, the copy of her medical marijuana card?
You don't have to provide it to the counter.
Okay.
If she does go in, she needs to make sure.
Provide, got it. Bless you.
Thank
Thank
All
you,
right.
Judge.
Thank you.
Have a wonderful day. Thank you,
Thank
Judge.
you, Your Honor.
Court does call the case, People versus Jonathan Weber.
Conrad Sorum, Batesville Township.
Morning, Judge John Shea with and on behalf of Mr. Weber. Your Honor, I haven't had a chance to file a formal appearance yet. Mr. Weber arranged my retention yesterday.
Okay.
We acknowledge receiving a copy of the complaint, waive its reading, and he stands mute at the present time.
Wait for a reading, standing mute. Court will enter a not guilty plea.
Thank you. Purposes of pretrial, Your Honor, I spoke with Mr. Siller for a few minutes prior to the court taking the bench. There's some discovery that we requested, which he will be providing, and we're asking for a 4-week adjournment of the pretrial.
Without objection, I'll adjourn this to March 19th, 2025, 9 a.m. As to bond alleged BAC.
Your Honor, it's a blood draw for search warrant .156. There was a crash where the defendant rear-ended another vehicle.
Your Honor, Mr. Weber is 63 years old. He's never been in trouble with the law before. Technically, it was a crash, although in fact, it was a very low-speed rear-ending at a red light. Virtually no damage, no insurance claim made. The search warrant was because Mr. Weber initially said he didn't want to consent to a blood draw, then changed his mind, and the police report says, I did a search warrant just out of caution because of the initial hesitation. But he did in fact ultimately consent after reconsidering his initial refusal. He is retired from the practice of law and is not constantly employed, does some things, and is taking care of some health issues as well.
What I'll do is I'll set the defendant's bond at a $15,000 personal recognizance bond. I'll order standard conditions, including no assault to behavior or possession of any weapons. There's to be no use of alcohol, recreational marijuana, or any illegal drugs. I am going to order, because of even though it being a minor crash, the accident, as well as the levels on his testing, I will order the defendant report to community corrections for placement on a Soberlink testing device.
Thank you, Judge.
Thank you.
Jonathan Weber's case carries a different weight, a .156 blood alcohol level, nearly double the legal limit in most states. Even though the crash was described as minor, numbers matter. Defense highlights no prior record and retirement from practicing law. That's mitigation, showing he's not a habitual offender. But the judge focuses on two factors, the accident and the BAC level. That combination triggers mandatory supervision in many courts. This is why he orders community corrections and Soberlink testing. It's measured but firm. Not jail, not remand, but monitoring. And here's something subtle but powerful. Even minor crashes change the court's posture. Public safety becomes front and center. When alcohol and vehicles mix, courts rarely take chances. At this point, guess you're seeing Judge Simpson's pattern, calibrated responses based on risk, history, and conduct.
Okay. In 4 weeks. Thank you, Your Honor.
Yes, sir. I did give that to you. I did. Okay. Court calls the case, People versus Angela Walker.
Ashton for the people.
Carolyn Foster Tucker on behalf of Angela Walker. Angela Walker.
Thank you. All right, where are we?
Your Honor, Ms. Londy and I have spoken. I believe we're close to a resolution, but we're just asking for a little bit more time. If we could adjourn it to the March 5th date.
Council, approach. All right. How long an adjournment did you need?
March 5th, Your Honor, if that's okay.
Adjourn the matter to March 5th, 2025, 9 a.m. or as your invite indicates. Ms. Walker, you remember our conversation on December 18th?
Yeah,
What did they tell you?
don't mess up.
What?
Don't mess up on my trick. Is that what it's called?
Your
My blow.
Soberlink?
Yes.
What did I tell you? No more missed tests.
Yeah.
December 24th, what happened?
It didn't charge. And so it had no charge on it and I had to wait for it to charge to blow in it.
And you missed the test block.
Yeah, I blew in it anyways, even though I knew it was going to be a miss.
This moment is loaded. Angela Walker missed a Soberlink test, and the judge reminds her directly, don't mess up. When a judge uses plain language like that, it's deliberate. Missing a test is not small. Courts treat missed alcohol tests almost the same as a positive result. Her explanation, device not charged, may be true, but from the court's perspective, responsibility lies with the defendant. Here's the key. Judge Simpson says he would typically remand someone for that. That means immediate custody. Instead, he chooses a SCRAM tether. That's stricter than Soberlink, but avoids jail. That's judicial restraint. But then comes the attitude comment. Courtroom demeanor matters. Judges notice everything: tone, posture, reactions. Compliance isn't just about devices. It's about respect for the process. Question for you. When someone misses a required test, should the court default to jail, or is a second chance appropriate?
Well, typically, when I give somebody that ammunition, that I would remand them. I'm not going to do that in this case. However, you will be switched to a SCRAM tether, then we don't have to worry about test. I need an order. I need a chance. So you'll need to report over to community corrections. Might as well do that while you're here. Turn in your you got to turn in your Soberlink and then get a SCRAM. All right. Thank you.
Thank you, Your Honor.
She might want to check her attitude. Can you go tell her to check her attitude?
Sure.
If she doesn't seem to want to listen, then just bring her back in and we'll check it. Ernie, see, I tried to do something nice. Middle ground. You're not buying it? No?
I thought it was
Wow.
very kind of you, Judge.
You're very kind of you, Judge, because I have clients coming up. All right. It took you a while to get there, but okay. Court calls the case, People versus Stephanie Hirsch.
Ashton, line for people?
Gabrielle on behalf of Ms. Hirsch, who's approaching the podium as we speak.
I gave her a warning.
So, please state your name for the record.
Stephanie Hirsch.
Thank you. All right, what are we doing?
Yeah, I did extend an offer to defendant. It's not, the terms of that offer have not been completely completed. So I believe defense counsel is going to request an adjournment to either fulfill the original terms of the offer or a modification that I made today that she can do to complete the last bit of it.
Okay.
Yes, the offer was to complete 10 hours of community service for dismissal. Ms. Hirsch is about a half hour short. So we're asking for an adjournment. I believe March 5th was the date that the court
She didn't count or just ran out of time?
Just ran out of time.
Oh, okay. Just kidding. All right. March 5th, she'll be able to get that by that 20. All right. I'll adjourn the matter March 5th, 2025. And where as your invite indicates. All right. Thank you. So how was she? She was okay? Was she? Was she? What'd she think when she saw you? Did she? Oh. Court calls the case of the People versus Dave Bloss.
Ashton, line for people?
It's an arraignment. Take hands out of your pockets. What's your name?
Dave Bloss.
All right, sir, you are before the court on a complaint that alleges that on or about November 2nd, 2024, the location of US 23 near East Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, count one alleges that you operated a motor vehicle with a high BAC. Do you understand the nature of that charge, sir?
Yes, sir.
That's a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
Count two alleges that you operated without a license on your person, commonly known as no ops on person. You understand the nature of that charge?
Yes, sir.
That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court cost. You understand that?
Yes, sir.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, please.
Public defender Fish.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Bloss.
Yes, ma'am.
We would waive any further reading, stay mute to the charges and ask for another pretrial date.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all charges. Pretrial in this matter will be adjourned March 5th, 2025, 9 a.m. Alleged BAC in this matter.
0.225, Your Honor. There was a single vehicle crash. The defendant that I can see has no priors. People are requesting.
Response to bond.
Your Honor, we would ask for a personal bond. If I may confer with my client for just one moment.
You may.
I can do this over. Or you can drop the corrections. If you want to. I can do this Soberlink. No, I don't. No. Oh. Your Honor, I explained the difference between SCRAM and a Soberlink. He is asking for a Soberlink device.
I'll set his bond at a $25,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of weapons. You understand that, sir?
Yes, sir.
There's to be no use of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, sir.
I am further going to indicate that the defendant is over to the Department of Community Corrections. I will place him at this time on a Soberlink device with the understanding that if he misses any of those tests, what is going to happen is he's going to be remanded. I may not use that intermediate sanction, given the level of alcohol.
That's my phone. That's me. Yeah. Okay. Thank you.
Court calls case People versus Kyle Burmeister.
Absolutely. For the people.
Hello.
How's it going?
Your name?
Kyle Smith Blue.
Pardon?
Kyle Smith Blue. That's not it.
You're not Kyle Burmeister?
No, I heard like commotion. I'm sorry. I guess not.
Okay. Why? You want to take his charge instead of yours or what? You don't know, do you? Kyle Burmeister? No response. I don't know why we. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500. Give a 10% privilege on that. That warrant will issue immediately.
Failure to appear is one of the fastest ways to escalate your legal problems. Kyle Burmeister doesn't respond, and within seconds, a bench warrant is issued. A $7,500 bond with 10% privilege means he'd need 10% of that amount to post bond if arrested. But here's the bigger issue. Warrants complicate everything. They signal unreliability to the court. Notice how efficiently Judge Simpson handles it. No drama, no delay, immediate action. When defendants skip court, they lose credibility instantly, and credibility is currency in a courtroom.
Court calls case People versus Billy Cobgilly.
Absolutely. For the people.
Sir.
Good morning.
What's your name?
My name is Billy Cobgilly.
All right. Sir, you are before the court on a misdemeanor complaint that alleges that on or about November 29, 2024, at the location of US 23 near Washtenaw, Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle with a high BAC. You understand that?
Correct.
And so you understand what you're charged with?
Yes.
All right. That's a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by a public defender?
Yes.
So public defender case.
Mr. Public Defender Natalie Pay, on behalf of Mr. Cobgilly, we would waive any further reading, stand mute, and ask for another pretrial date, please.
And then having waived formal reading, standing mute, will enter a not guilty plea. Discharge. Pretrial in this matter will be adjourned. March 5th, 2025, 9 a.m. as your invite indicates. As to bond in this case, that's BAC.
Your Honor, this is a case that involves alcohol and marijuana. So the alleged BAC was 0.188. There were also detected in the defendant's blood 10 nanograms of delta THC. People are requesting Soberlink or SCRAM tether, as well as at least intermediate supervision at community corrections and a no marijuana condition.
Pete, you may want to.
Oh, sorry, Your Honor.
Yeah,
I've been
it
bad
came up,
at,
it was red.
I've been bad at that today. Your Honor, we would respectfully request the court consider a Soberlink breathalyzer, but we understand if the court would order a SCRAM.
Well, I don't know. Right. All right. So 188. There was no accident, you said?
There was no crash, and I don't show that the defendant has any prior history of OWI offenses.
How old are you, sir?
30.
Do you have a medical marijuana card or no?
No.
I've adjourned it out to March 5th. I'm going to order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no possession of any alcohol, recreational marijuana, or any illegal drugs. I'm going to order it also that you're to report to community corrections. I'll place you on a Soberlink testing device at this time. My minimum testing on that. I'm also going to order at this time drug testing 2 times per week. Since he doesn't have a card, that level is going to have to go down. He needs to understand that we can get the levels on it. So if he's using, we're going to know.
This case combines alcohol and marijuana, an alleged .088 with detectable THC levels. Even without a crash, that mix raises red flags. The judge emphasizes something important: THC levels can be monitored. If levels rise, the court knows usage continued. That's why he orders twice-weekly drug testing. This is supervision layered intentionally. Community corrections, Soberlink, drug testing. It's not punitive yet, but it's structured control. And here's the broader implication. Legalization doesn't eliminate consequences. Driving under the influence remains illegal regardless of recreational status. Would you have required a SCRAM tether here instead of Soberlink?
All right. There's a $20,000 personal regardless.
Thank you, Your Honor.
I want him to report over it today. First.
Absolutely, Your Honor. And for the Sober. Yes, correct. Thank you.
Soberlink.
Absolutely, Your Honor. Thank you.
Thank you. Court calls case People versus Ashton Ebler. Your name?
Ashton Ebler.
Sir, you are before the court. Registered vehicle. It's a 95. Do you have the penalties, Mr. Solero, on driving an unregistered vehicle?
Your Honor, that is 90 days and or $100.
Is it 91? Okay.
90.
All right. Sir, you are before the court on a misdemeanor citation that alleges that on or about January 18, 2025, at the location of US 23 and Michigan Avenue in Pittsfield Township, that you drove an unregistered vehicle. Do you understand the nature of that charge?
Yes, sir.
That's a misdemeanor punishable by up to 90 days and a $100 fine plus court costs. You understand that?
Yes, Your Honor.
All right. First question I have for you is, do you want to be represented by an attorney on this?
Yeah, I'd like to speak to somebody.
Pardon?
Yeah, I would like to.
All right. This is a public defender.
Good morning. This is Public Defender Lauren Kearney on behalf of Mr. Ebler, and we were asking for another pretrial date, Your Honor. Waive any further related charges.
Been in every way, form, or reading, standing mute, or will enter an act. Pre-trial in this matter, I'll adjourn this out to March 19th, 2025, 9 a.m. Set his bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
Yes, Your Honor.
I'll order no alcohol, recreational marijuana, or any illegal drugs. All right, you're all set. We'll see you in about a month.
Thank you.
Thank you.
Court does call the case, people versus El Haji Faye.
Have some money, people.
El Haji Faye. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. Well, actually, no, this first show, isn't it? I'll order a show cause. Court calls case people versus, is it Emily Fox?
Have some money for the people.
Emily Fox. No response. What's the alleged BAC in this matter?
Yeah, this is a drug case.
Oh,
So
it's
the
drugs.
alleged drugs that are, the drugs that allegedly were found in the defendant's blood include fentanyl, methamphetamine, and amphetamines. There's a 2 vehicle crash.
Got it. I'm going to, for those reasons, in public safety, skip the show cause portion. I'll show bench warrant for defendant's failure to appear. Bond is set in the amount of $15,000. I'll give a 10% privilege at this time, but that warrant will issue immediately.
This is where public safety overrides leniency. Fentanyl, methamphetamine, amphetamines, and a 2-vehicle crash. That combination is severe. The judge explicitly says he's skipping the show cause and issuing a bench warrant immediately. That's escalation. A $155,000 bond with 10% privilege signals significant concern. When controlled substances like fentanyl enter a driving case, courts react strongly. This is not procedural housekeeping. This is containment. The message is clear. Failure to appear plus serious drug allegations equals immediate consequences.
Court calls the case people versus Michael Hale.
Have some money for the people.
Michael Hale. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of $5,000, 10%. That warrant will issue immediately, there having been a previous one. Court calls case people versus Michael, is it Clustra or Clustra?
Have some money for the people.
Good morning, Your Honor.
Good morning, your name?
Michael Scott Klustra.
All right. Sir, you are before the court. The original one. On a misdemeanor complaint that alleges that on or about October 23rd, 2024, at the location of Hogback Road near Clark Road, Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle while intoxicated. You understand the nature of that charge, sir?
Yes, sir.
All right. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney, sir?
I do not have an attorney today, but I am going to get one.
You're going to hire your own?
Yes, sir.
Do you know when you're going to be able to get that accomplished?
Hopefully today when I get home.
And what I will do is at this point, I will indicate that you're not asking for any further reading of the complaint in this case, understanding the nature of the charges and the maximum penalties. I'm going to indicate that you're standing mute to the charges. I'll enter not guilty plea at this time on your behalf. You understand all of that, sir?
Yes, sir.
Alleged BAC in this matter.
Your Honor, a drug OWI, 10 nanograms of delta 9 THC, a single vehicle crash. The defendant has no prior OWI history that I can see.
You have a medical marijuana card, sir?
I used to before it was legalized here in the state of Michigan.
So the answer to that is no.
Yes, sir. No, I do not have one at this time. Sorry.
I'll set his bond at a $15,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior. There is to be no possession of any weapons. Also, there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will order that you are to report over to community corrections for drug testing. At this point, I'm going to order 2 times per week drug testing. I signed that order. You might want to stop by there right now. You have to appear there within 24 hours. You might want to stop before you leave the campus here. I will adjourn this matter to March 5th, 2025, 9 a.m. or as your invite indicates.
Sir, may I ask if I could have that date changed to the 19th or 26th of March?
Why?
My wife needs to drive me because I have epilepsy. So since that crash, I can't drive for 6 months.
All right. She's here with you.
Yes.
All right. Will the 19th, I understand that. Will the 19th work for you to get him here?
I would like to have the 5th work. I'd like to take the 5th if we can.
Do what?
Or do
The 5th? Oh, the 5th would work better.
You wrote down, okay. I'm sorry. She wrote down 2 dates. So
Who wrote down 2 dates?
my wife wrote down 2 dates.
And you read the wrong one.
No, she wrote.
No, you read the wrong one. She said the 5th would work. You should have asked. You know what?
The 19th.
He was up. No, he was up here trying to make his own decision.
Never.
He should have turned around, asked, and said, "Dear, what day should I choose?" He said, "I had to get involved in that. You want the 5th, ma'am?" Okay. See, if he just listened, right? If he just listened, there wouldn't have been a problem. The 5th. All right. No, don't try to, you know what? Don't try to redeem. Do not try to redeem yourself. All of these people know that you were wrong.
This final exchange is almost comedic, but it reveals something important. Michael Claraara tries to negotiate dates without consulting his wife, who drives him due to epilepsy. The judge calls it out directly. What looks lighthearted actually reinforces a principle. Preparation matters. Communication matters. Court is not improvisation time. Judge Simpson uses humor, but he also reinforces authority. The bond is set, drug testing ordered, conditions clear. Across this entire docket, we've seen calibrated responses. Pleas accepted, warrants issued, testing imposed, chances given, and boundaries enforced.
Yes, sir.
All right, thank you. Take care. Have a good day, folks.
Today's session covered the full spectrum of misdemeanor court proceedings under Judge Simpson's bench. We saw a multi-case retail fraud resolution where strategic plea negotiations narrowed exposure. We saw DUI cases with varying BAC levels result in calibrated bond conditions, from random testing to Soberlink devices to SCRAM tethers. We saw the court respond differently to .088.156.225, demonstrating that numbers influence judicial posture. We also saw the consequences of non-appearance, immediate bench warrants, and in drug-related cases involving fentanyl and methamphetamine, public safety concerns triggered more aggressive bond measures. Across every case, Judge Simpson balanced due process, public safety, and accountability. Monitoring was imposed where risk was elevated. Leniency appeared where records were clean. Escalation followed non-compliance. The broader implication is simple. Misdemeanor court may seem routine, but each decision carries layered consequences: legal, financial, and personal. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.